open standards have to do with the technical access to information or open data about the contracting procurement market, but the concept of transparency in public procurement is a little more general, a little broader. The Integrity Pact has a slightly broader scope, as will the matters we will be discussing with Mr. Nowak and Mr. Haładyj. So we have a context. There's a draft of the new public procurement law. There's a proposed bill, and the question is, to what extent can this new law facilitate, or will it be conducive to more open contracting? So that's the scenario, that's the logistics, and then we'll go back to details during the workshop session. I'll be running a workshop on the risk barometer in public procurement, which is a product of open contracting, and about the open contracting standards and the Integrity Pact. That's the topic of the workshop. So without further ado, it's over to our moderator, Katarzyna Batko-Tołuć from Watchdog z Polska. Moderate away. Thank you very much, Katarzyna Batko-Tołuć. I feel like I represent the public, I represent the audience, because I do have some more time to ask panelists questions. We don't have a lot of time, so I'm very happy to welcome our former compatriot who understands Polish, as far as I know, and likes Polish people, as far as I know. And so, Karolis, maybe you can tell us about the concept, about what open standards are in public contracting.
I do love Polish. That is true. Good morning. I had this fascinating talk with a taxi driver this morning. I came from Vilnius, and he didn't speak English or Russian. He spoke only Polish, but what I understood was Milosz, nasz, Pilsudski, nasz, Mickiewicz, nasz. And I'm like, wait, Mickiewicz is more than a national, you know, it's a human being. It's so big, you know, it goes beyond like nationalities and everything. Anyway, very happy always to be in Warsaw. I'm from Vilnius. My name is Karolis. I work for the organization called Open Contracting Partnership. And my job today, I've heard a couple of times Grzegorz talk about Open Contracting Data Standard, but don't be scared. This is not going to be too technical. My job today is just to explain the philosophy of open contracting and just to set the scene for the day, because hopefully what's going to happen today is we will have discussions with the principles that the international community and Poland and European Commission and open governments worldwide promote. So let's start maybe quickly with my organization. So I have like 10 minutes probably maximum, right? So I'm just going to... 15, okay, cool. Are you going to help me with slides, or?
I think you should have...
It's a privilege. And that is my organization. It's an organization that works with open data solutions in the field of public procurement. So we probably all know what open data is, which is...
It's working, and you may even...
Oh, wow. Oh, that's even better.
IT.
Okay, fantastic. So basically what we do is we promote technical solution to open data in the field of public procurement, which is open contracting data standards. And we also work with philosophy of open contracting, and that means that we work with policy side of things and strategy side of things. As you might be aware of the ideas of open data, disclosing and publishing open data is not enough. That is the first step. So everything that happens beyond that, which is asking questions such who will be using data, how that data will be used, what kind of mechanisms do you need, how does that impact policy, most importantly, how does that lead to better procurement, even more importantly. Those are the questions we're trying to answer. So I'm based in Vilnius. I cover the European region. So currently about 40 countries in the world implement open contracting data standard. So let's continue to next slide. Grzegorz? Oh, I've got it. Okay, cool. Let's start with a cold shower and reality check. Okay, so let's start with what we know for a fact. Okay, so from working in the field of public procurement with a lot of governments, I can tell you that not a single government can tell exactly how their tax dollars are traveling from budgeting to invoicing. Okay, and we know that technology allows that. And that is a lot of money. It's about 15 to 20 GDP annually per year. Poland, I think, spends about 12-14% of their GDP through public procurement. So it's a lot of money. And the reality of the matter is that nobody can actually track how that money travels through the system. Okay? That's the first point. The second point is that not many governments are actually thinking proactively and smartly about value for money. So the question is, do you actually get the best price for the best service, work, or goods as a government? Very difficult to tackle. Not many governments actually have decent, proper data and good methodologies to do that. Nobody knows exactly, but about 30% of public procurement money is wasted on corruption. I would also say inefficiencies, ineffectiveness, incompetencies. So about third each $1 out of $3 is wasted on things that we can actually control. From my own experience, speaking with governments, a lot of governments in the region talk about lack of analysis of, capacities in their departments and in their sort of governments, meaning that, yes, even if we have data, not a lot of people can actually analyze that data, understand what is behind the data and things like that. We also know that public procurement is number one corruption risk worldwide. And lastly, European Parliament thinks that about 5 billion euros annually could be saved, let's put it this way, every year. Right? So this is the reality check. I'm happy to discuss any of those points, but I would be confident to actually defend them. This is the bottom line is that with so much money, which is about $9.5 trillion in government's hands every year, governments mostly spend their money just like this, roughly having an idea of where the money travels, but not exactly knowing how to track it. Now, where we step in as an organization, our idea is this, and this is not a new idea, definitely, but what we're trying to do is we're trying to apply data solutions in the field of public procurement again. So the theory of change, let's put it this way, is this, that we start with data, right? So first of all, we believe that every public procurement system should have spotless, high-quality, well-structured data that is published timely, right? So that's step number one. Leading to step number two, and that is people and organizations looking at that data and analyzing and producing insights. Nothing new in the technology age, right? This is old news for many, many businesses and people. Governments do lag behind these ideas. And thirdly, that leading to the action and engagement. So governments actually making changes based on the insights provided by data. So this is the general idea of what we do. We work with open data, open contracting data standard for data publication, leading to methodologies and methods to use that data. Mostly it's dashboards, statistical portals, and mechanisms offline, leading to closing the feedback loop, meaning the government takes action based on the insights that it gets from people, citizens, business associations, its own departments. So that's the idea. Now, the first corner of the triangle, data. Right? So my job today is also to present open contracting data standards. So you don't have to know a lot about it, but what it does basically is it provides technical specification of which data should be disclosed how. Right? Meaning that within each of these 5 contracting cycles, stages, from planning to tender, award, contract, and implementation, there is a list of information that we recommend how to disclose in terms of technical side of it. So, for instance, in the tender stage, you would have information related to procurement procedure, criteria, dates, amounts, line items. And all of those are standardized so that you have, for instance, 1st January 2019 as opposed to 2019, January 1st, across the departments. Now, as I said, you don't have to know a lot about the standard. This is really a technical thing. This is for somebody who works with databases, works with data. But what you might want to know is that the standard is a global open data schema, meaning that the global community agrees on a standard way to publish public procurement data, right? So it's global and non-proprietary, so it's free. We as an organization don't own it. It's an open data schema. It's open source, kind of a philosophy behind it. It's extendable, so if you do have more data than the standard standardizes, there's absolutely no problem. You can extend your data sets. We, as an organization, watch how the standard is being used globally, and then we extend the standard based on the practice. And lastly, as I said, it's non-proprietary, which is very important. So it's not a product that we promote. It's the idea that the global community can come together, can agree on a certain way to disclose and publish public procurement data and follow that. Now, it may sound like a big deal in terms of a technical solution, but it really isn't. So you don't have to understand that slide much, but it helps me just to structure my thoughts in a way that what you have to know is that open contracting data standard does not bring a revolution to your e-procurement system. You can have an existing e-procurement system, and you can build open contracting data standards on top of it. You can use it as an integral data model inside. You can use the standard basically simply, and in the worst case scenario, just scraping data from the websites and then standardizing it in open contracting data standard. So the message is that it's an easy to use, not complicated way to disclose data without interfering with your systems too much. So everything I've said up to now is basically this. Right? There's a lot of data. If you think about a standard tender documentation, or let's say a contract, there's a lot of data there. There's company name, there's date, there's subject, there's item, classifications, and things like that. And it can be so messy within, I think in Poland you have 14 or 15,000 contracting authorities. So across all of these contracting authorities, if you want to do any kind of analysis, if that data is not clean and structured, there's no way you can actually do that. So if you want to know how much you paid for a bottle of water in Warsaw compared to a bottle of water in Gdańsk, I don't know if you can do it now. But if you have your data in the right way, you can actually do it very quick. Having said that, technology is not the only solution. Technology is the start. And technology is something that we know how to do. Right? So it's not easy, but we know how to do it. We can start working with the systems. We can implement open contracting data standards within a span of few months. That is possible. Now, what's even more complicated is that to get to the impact, it has to go beyond technology. Right? So first of all, we should be looking at a systemic reform. So it's not only about publishing data and then hoping that the best will happen. It's really about thinking about what you want to achieve. Are your levels of competition low? Do you have a lot of single sourcing? Do you have a lot of corruption in the system? Collusion cases and things like that. So as soon as you know what your problem is, then designing the data publication action is so much easier. And we help governments do that, actually. It takes extensive communication. So you have to go out to the markets, talk about your new systems and new data opportunities and new information analysis opportunities to be able to engage them to use the data, which is a very, very difficult thing to do. It has to go through a whole chain of contracting. Ideally, and I hope Eliza will tell you more about the idea of connecting dot between national budgeting all the way through invoicing. That's even better. If you want to go beyond that, twinning the data with beneficial ownership information, for instance, that's even better. Opens up opportunities for, conflicts of interest monitoring, for instance, and things like that, as an example, which is point number 4. And but we, as an organization, we can help you do that. So there are a standardized way to get to from the very beginning, which is thinking about your problems and thinking about what you want to know about e-procurement, from the very first questions to the very end questions, such as how do you carry out the initiative from the technical perspective and also from the policy perspective. So we, as an organization, can help governments think about these things. As I said, about 40 countries currently implement open contracting data standards. It is becoming a global norm already. The European Commission highly encourages countries use it. We are working to bring it in compliance with TED data structures. G20, G8 promotes it, and other international fora such as OGP, Open Government Partnership, OECD, and EBRD, and World Bank Group, and other partners. So it is becoming a global norm. Now, and I'm going to probably finish with that, which is the most important probably slide, is that when I said that technology is important, but it's not really an ultimate solution for everything, I want to give you a taste of what we have managed to achieve in some other countries. So implementing new system based on open contracting data standards in Ukraine, for instance, generated about 12% of savings. And we can discuss about the methodologies of savings and everything, but in Ukraine it actually works. The methodology that might not work in some other countries, in Ukraine we are actually confident to say that this is the money we help the government save. European Commission research shows that every single bit of public procurement data disclosed reduces the risk of single bidding by 0.05%, meaning saving ultimately money through more competition. So the idea is that every single bit of information really matters, and if you disclose it in a highly sort of clean and structured way, that's even better. That might lead to even more impact. We saw in Ukraine that competition and supplier diversification increased drastically, and this is one of the first impacts we see emerging in open contracting initiatives. And that is competition and supplier diversification. The idea behind that is this: as soon as you have more data coming out of the system, more clever business intelligence solutions or data analytics solutions, business do actually engage with these tools and make their choices in a better informed way. We see also better feedback mechanisms. So a lot of governments are afraid of opening up too much because of too many potential complaints coming in. So we saw that happening to some extent in Ukraine, but what we also saw is that quality of complaints increased. So there's more complaints, but there's also more satisfaction. So we believe that that is because those who complain use data and BI, business intelligence solutions, to actually inform their complaints and formulate better complaints. So it does actually improve the quality of work of complaint bodies. We see that 80% of businesses in Ukraine are happy with the new system, which is a drastic a number, we believe, considering the country and the environment it found itself in 5 years ago. We see that in the first year of the reform in Ukraine, the perception of corruption, so people believing that there is corruption or not, in the business community participating in public procurement dropped by a half, which was a drastic drop. So those are the ideas that we speak about, right? So we do have a technical teams working full-time, helping governments free of charge to implement open contracting data standards. And that is something that we're very good at, because there is technology solution, and we can help governments do that. The trickier part is thinking about what do you want to know about your public procurement, and what do you want to fix? And that is where a bit of a brain power is needed to understand how to shape these initiatives. But very happy to sit down with any of you and to think through the potential, design solutions to make sure that the data that you are going to be disclosing in the near future is used for the benefit of public procurement and the quality of public procurement in Poland. So I did have a number of examples also to show, but I sense that probably I'm running out of time. So I'm going to stop here. So unless you have any burning clarification questions, I guess I will go back to the panel. Yeah? Okay.
Proponuję, żebyście państwo...
I suggest that you jot down your questions because we would like to move on to hear from Mr. Mariusz Haładyj. You'll be able to ask him questions, but all the other questions will be moved towards the end. So let's be flexible about it. Well, thank you very much, and sorry, interpreters couldn't hear the comment. Now, your experience is much broader than the position that you are at the moment, and, beyond your function. And I suppose one can learn a lot as you've experienced interactions with both the private and the public sector, and you've been involved in studies and analyses. So I'm sure we will all be interested in hearing your comments as a representative of the government attorney and your impressions of the government contracting in general. Thank you very much, and do apologize for disrupting the agenda a little today. Let me start from the last aspect, the general, and I'll be moving from the general to the detailed. Now, what I'm going to say is linked to corruption and corruption prevention, and I suppose this has been our buzzword ever since we started working on legislation, and that is we strived to ensure that there is higher competition in government contractors. So apart from transparency and access to information, competition is one of the best tools, if I can call it a tool, conducive to prevention of undesired developments. The way we approached drafting the bill was mainly let me phrase this in the following way. I'd like to use the language of public procurement rather than government contracting or contracting, and having said that, public procurement has been split into three areas. That's the way we structured things. Now, contracting is just a selection of the contractor, but we believe there are more steps to it. First, you have to make an analysis, a pre-contract or pre-procurement analysis. So what you need is to plan, then do it, select the contractor, and then evaluate. And so, in fact, there are about 5 such areas, and we have ensured that each step has a adequate framework about it or around it, just to make sure that the whole process is a continuum. Now, in the public market, institutions and companies spend their money and make sure that every penny or every cent is adequately accounted for. So that's mainly the private sector's focus, and we want to do the same. we want to ensure that there's a similar approach, or the same approach really, to public procurement or the public sector. So first, it is critical that we review the particular project prior to tendering. So we need to identify what we need, whether we need it, and how we need to approach the procurement. And at the end, we need to evaluate how that procurement has been executed and how effective and efficient it is or it was. So we take the view that we need to exercise stewardship of the public funds, and we're talking about huge sums of money. 200 billion zlotys is the entirety, is the totality of the public spending per annum. Of course, we don't ignore procedures, but procedures are just a means to an end. Procurement is, in general, a process where we satisfy public or individual needs, individual in the sense of social needs. So we have worked with the Public Procurement Office, and first we identified or defined 9 programs that we would like to be covered by that document. And if I were to select one, would be an overall program to increase competition. We have about 1/3 of projects in this country where there is only one bid, which is quite a concern. The first, so the second piece of information is that 9 out of 10 tenders are executed in an unconfined tender process. It appears to be the most competitive of the procedures available. However, I feel it is safe, but not always best. If we want to improve competition, if we want to involve small and medium-sized enterprises, if we want to capture the mythical innovation, open tender, unconfined tender shouldn't be used in 9 out of 10 projects. Plus, we have single source, which is another extreme. So in terms of negotiation-based processes where the client is not shying away from speaking to the market, there is too little of that. And the way we look at negotiation-based processes is not that they lead to undesired phenomena, corruption. We believe that if it's done right, it's the best way to execute procurement. Especially if we are talking about sort of more ambitious projects, where price shouldn't and must not be the core criterion. So that was our thinking at the source of our work on the new bill. And as a government attorney office, I can say that this is exactly what the government wants. It is critical that in any disputes with contractors, well, generally, the government doesn't want disputes and doesn't want to be involved in litigation. What the government wants is a timely delivery of quality products. Note that public procurement is there to satisfy, to pursue general interest goals and social needs. So our office supports that approach. We want to ensure that public procurement is smooth, and if there are disputes, they are natural, they should be handled swiftly and efficiently. Of course, when we part with a contractor that we can't settle with, if we are going for another contractor, that usually increases the price, sometimes by 50%, sometimes by 100%. So disputes, long-term disputes, unsettled disputes, or unsettleable disputes are not exactly good. There are also ramifications, or let me put it this way, there are important aspects related to drafting agreements as well. The government shouldn't be the most aggressive, and is usually not the very aggressive player in terms of putting a lot of twisted language in the contracting phase or in the contract. It must be balanced. It must be structured. So this is where we come in. Our office, the government attorney office, is there to ensure that government has adequate, clear and balanced contracts, so that parties understand that the contract is clear and clean. And it means people are not starting to collect evidence for future possible litigation because they know the contract is unbalanced and it's tricky. And in Article 54 of the Public Finance legislation says that government can also settle just for the sake of ending disputes. So now transparency. I jotted down several points in the legislation, in the draft legislation we've been working on, that to my mind improve transparency. Now we met about 3 years ago and we discussed public procurement and we talked about transparency. So we learned from that and we proposed that per procurement above 50,000 zlotys should be publicly notified. It's not public procurement per se, but this should be public knowledge anyway. It's much more difficult for the client then to award a contract to a friend, if you like, to John or Samantha, if I can use some fictitious names. Secondly, we would like to create one-stop shop for government contracting plans, and we want updates to be more frequent than once a year. And we want sub-threshold projects to be notified, publicly announced, and then again we want to ensure that there is a one-stop shop for that, so that contractors are in the clear, potential contractors. And thirdly, and it is again something that fits into the presentation we've just heard, analytics. Of course, prior to a contract, we cannot plan everything, and I'm sure Hubert will fill us in terms of what we need to be aware of, because he's also involved in this phase a lot, and we spoke about it. Anyway, new technology and analytics. This is something that the Ministry of Enterprise and the Public Procurement Office, they want to increase the involvement of technology. And we have earmarked 10 jobs for analysts who will be sitting in the Public Procurement Office to ensure that that we understand the building blocks, just to make sure that we get to the last picture where data is structured and where thousands of entries are nicely sort of laid out. And we want to use artificial intelligence and machine learning to support that. It is with great regret that I have signalled time up. Now, ladies and gentlemen, we have 5 minutes for questions. Sławomir Śnieżko, Anti-Corruption Academy. I have a quick question to you, Minister. You said that public procurement market in Poland was about 200 billion zlotys. The previous speaker spoke about 30% of public procurement burdened by corruption. So if you add that, the numbers, you would see about the 60 billion subject to corruption. Maciej Wnuk, I write guidebooks, and I have a question about e-catalog. I find it a very interesting tool, but it has a drawback. It doesn't offer quite a large number of both clients and bidders or contractors. Are you planning, while using the existing tools, are you planning to promote e-catalogs? Are you going to perhaps use e-catalog as a platform for notification of sub-threshold projects? Dariusz Zieliński, KZP law firm. The last Saturday hackathon revealed several points, including the need to exercise a needs assessment, create alternative solutions, then meeting with contractors after the best offer has been selected, and thirdly, about evaluating agreements or contracts. And people have been pointing out that these were time-consuming steps. Transparency, I would like to plea that we don't take a step back. I believe transparency is at the core of the new legislation, and I suppose you might want to review the language on the meetings with contractors to allow them more time to prepare. Today, the client, after 20 years of this law in force, Some clients reveal their documentation on the last minute, which means people have no time to prepare. And lastly, there's something that I find quite surprising, and I don't agree with this. If you look at statistics over the past 6 months, if you look at the jurisprudence of the National Appellate Chamber, 3/4 of cases before the Chamber are related to false information and restricting information as commercial secret. And this legislation doesn't respond to that, because false information falls into the optional package, which I find unacceptable. As far as commercial secrecy, nothing has been improved in the legislation. What's more, access to information has actually been limited. And the pretext here is the data protection. And now lastly, cities are allowed to confine their public procurement to local bidders, which is not helping competition. And litigation and disputes, I suppose disputes should be handled by district conciliatory boards. This is a great vehicle. I'd like to ask you, sir, and this is related to the mandate of the government attorney office, and this ties to my later comments. There's some confusion and misunderstanding around corruption in public procurement. Some of that corruption potential could be eliminated if disputes were to be referred to alternative dispute resolution mechanisms, non-litigation, even if courts were to just monitor that and approve of that, but this wouldn't be litigation proper. It should be, I don't know, mediation, settlements and conciliation, etc. So I see great potential for the government attorney office to be involved. You should be supporting that, perhaps, and you should be the steward or guarantor of transparency of such dispute resolution approach. I've recently met with a contractor, and what I heard was quite disconcerting. I have heard that the government attorney office doesn't have the capacity to do that. So can you comment on that?
The first question concerned the high rate, the 30% of assets which are spent or at risk of corruption. And in the meantime, Eliza and I concluded that this is a very broad definition, and mismanagement of funds, that's another risk. When talking about corruption, I think this is whenever I think of corruption, I see that as the worst, like evil, mismanagement of funds, which isn't always intentional. I mean, corruption, as I understand it at least, so I tend to understand corruption in the strict, literal, criminal sense, that it's intentional for particular reasons and with particular motives. And if we understand corruption like that, then 30% would be excessive, would be exaggerated, and I would disagree. But I feel that in Poland, we can save a lot more if we managed the funds better, if we planned better, and if we planned our purchases better, if the planning stage were better done. So by defining the specifications, by the conditions, the terms, the line items, what I want to actually purchase, procure, and instead of bidders competing just on price or simple parameters. And the British example shows, and this is one of the reasons our office went this way with the new bill. The British equivalent of our office has determined that the greatest savings, hundreds of millions of pounds annually, were gained with the support, if their office supported employers or contracted authorities. So providing expert support, expertise during the contracting stage. It's not a question of taking over the responsibilities of contracting authorities, but answering questions, resolving doubts that arise in the process. And there's a lot more potential for savings. Again, I wouldn't call it corruption. I'd rather think of mismanagement or maybe playing it safe. So if I buy, for instance, a good or service that's maybe not... or maybe if the procurement process isn't done in an optimum way, at least nobody will accuse me of mismanaging public funds because I do it by the book, right? And there's a lot of potential here. I don't see a risk of corruption. As I see it, the risk of corruption isn't that great. It's not at 30%. I wouldn't put it that high. As for e-catalogs, maybe I'll ask Hubert to respond later on. We considered using an e-catalog, but then we decided not to. Hubert can give you the details. And the last issue relates the three proposal solutions, a selection of variants, meetings with contractors, and then evaluation. I'm glad you mentioned this because these are things that contracting authorities might not necessarily like too much because it means the process is more labor-intensive, but it's a way of avoiding the risks because we can trace it back. We can say why I chose a specific procedure for my tender, for my procurement. And also evaluation, if there are some mistakes or irregularities. But this evaluation tool, I think, can be useful as a way of learning from mistakes, as learning from one's own mistakes. I don't want it to be an instrument of control, of audit. I don't want these evaluations to serve as the springboard or starting point for some audit. That would be, instead, evaluation ought to be a learning tool for contracting authorities to help them so that they don't make the same mistake twice. And meeting contractors, that's something I chose to address last. And this is where contracting authorities have the most complaints, maybe. You said that there ought to be more time to analyze, to read the documents, but I wouldn't want... Exactly, I don't want it to be an appeals procedure before the prior to involving the Chamber of Appeal or the appellate chamber. It's something that was that worked in Canada. I think Canada can be a fairly good model for us. And in Canada, the idea is to educate contractors. What we often have to deal with is especially smaller companies. For instance, they bid in a tender, they don't win the contract, they're not awarded, and then they say, well, I won't do that again because it cost me 2 months' work, and the tender was rigged anyway. So there's no point in bidding because once and it only goes to show that tenders are rigged. So once burned, twice shy, and so the purpose is to show in a more communicative and friendly way than by way of an official a document, because small companies don't have the legal or capacity to. So the point is to identify the shortcomings of a bid so as to encourage the business to bid again without making the same mistakes twice. And in Canada, there's a second goal they have, because that served to reduce the number of appeals, but not because bidders or contractors went through all the paperwork, but because they learned from officials at the contracting authority end what were the reasons their bid was turned down or was not. So that's a more effective, a much better way than creating yet another appeals procedure. And another matter that has to do with conciliation and Grzegorz' question, again, which ties in with what you mentioned regarding conciliatory courts as the attorney of the Treasury. My predecessor, I'm working with my predecessors, and they've been supporting the idea, the concept of a conciliatory closure. The best example is the conciliatory proceedings with the National Stadium, which allowed us to avoid years of litigation and save money, and also regulatory changes. The draft was done together with the Prosecutor General's office. So as the Attorney of the Treasury, this way of conflict resolution, conflict resolution is something we promote. Of course, in cases involving the state treasury, it can't be dogma, it can't be writ in stone. But as the Attorney of the Treasury, we support the concept of a conciliatory chamber. And why should this chamber be part of the Chamber of Appeal and not audit bodies? Why in smaller cases where the Chamber of Appeal does not have to be involved mandatorily, we can provide for other ways of conflict resolution, but as far as based on our knowledge of the way the administration works, the Chamber of Appeal, which I think has worked out some best practice, which has proven itself in working with contractors, and they're appreciated for their work, not just for the speediness of resolution, but also the way, companies have told us that it helped many companies effectively. So, but we have to remember that the Chamber of Appeal, which is not a private, it's a quasi-court of conciliation, and it gives contracting authorities a greater sense of security. They feel, they give them reassurance. And so we're suggesting that the conciliatory court be obligatory, but it's difficult to envisage it's difficult to envisage the law recommending mandatory use of private conciliatory courts. I think that's not the best way to go. So, which is why we chose to have this conciliatory system as part of the Chamber of Appeal. And if the General Office of the Attorney of the Treasury, and maybe if a takeaway of this meeting would be encouraging people to work or come to support our work, that would be good, but I've had conversations with people who are mediators or who represent contracting authorities, giving them reassurance in these conciliatory negotiations. We have 280 staff at the attorney's office, including 130 solicitors or legal counsels, as they're called, who are competent. But again, is that enough? That depends on which way we go. After the amendment of the Act on Public Finance last year, we had 3 times as many conciliatory proceedings with the State Treasury, thanks to the support of the Attorney of the Treasuries. So a 3-fold increase over last year, I think, is desirable, is good. So I wouldn't say that our office doesn't have the capacity, isn't able to take part in mediation or conciliatory proceedings, but it can't help. It can't help every contracting authority or every public body. So we need to realize what we're capable of and perhaps focus on the most complex cases, which is not to say the cases, the largest, most extensive cases. We've helped public schools, for instance. So these aren't disputes involving billions and billions of zlotys, as you can well imagine. There could our capacity could be increased, but I think that our office is doing a good job, and the fact that people are going for conciliation increasingly is a good sign. So I can only hope that we don't break the mechanism, but continue to support the office in the way it's been headed. Thank you very much, and thank you very much for going over time slightly. And now we can move on to the next part. Now maybe we could ask for another round of comments or statements from each of our panelists. Let's get back to open contracting, how that can be improved. But we've also had the interesting case of Ukraine, and as the EBRD, I'm sure you were involved in similar cases. Perhaps you could share your expertise with us. My name is Eliza Niewiadomska. I'm with the EBRD in London, where I'm in charge of supporting structural reports in European countries or in countries wherever the government is reforming the economy. Our bank's mandate is to create a climate for investment, a climate for SMEs, and to create a market that supports an economy that's environmentally friendly and that caters to the needs of the local communities. Today, the organizers have given me 5 minutes to tell you about or to comment on what Karolis said in his presentation. The presentation is in English, and I apologize for that. I did commission a translation, but I didn't like it, so we're staying with English. And as far as commentary, the EBRD has been working with the Open Contracting Partnership for 4 years now. So ever since the standard was established, and we did meet in Ukraine when Maidan ended, when the revolution in public administration in Ukraine also began. There's a lot that's changed in Ukraine as far as the organization of the government, the local government operates. The goal in Ukraine was to determine how money was spent, how people are doing that, and how procurement should look. A country which is in the throes of economic crisis, where nobody wants to join or work in public administration. So how can you set up, how can you run public procurement well? And this is an example, that's a textbook example from an economics textbook. So when people buy for yourself, for their own money, they take all the considerations into account. But if they buy for someone else for their money, then they don't. And public procurement law is an instrument that wants to adjust this relation. So how do we work with Open Contracting Partnership? First of all, we try and draw attention, we highlight that to regulate public procurement, we need to factor in the mental element we have. So if we're doing something for ourselves, we do it better, we take more care. And the more we know, the more information is out there on the market. How public bodies procure, pay, then it's the economy benefits. And this is not this is a fact. This is a cold, hard fact based on data from countries that publish, and we can show you the numbers. Working with OCP, we're trying for each country where we have a presence. We try and find a balance between how much transparency is needed and how to ensure value for money and a smooth operation on the market. And this is a balance that's important because we have legislation that opts for transparency, and then nothing works because everything is so slow and ultimately it's not transparent. Or we have regulations where there's no transparency, everybody happy, as in Russia. In Russia, the procedures can be completed within a month, but people have no say as to who's awarded the contract. So one of our goals in this cooperation was how to marry, how to have a single solution that would blend open contracting, transparency, and user-friendliness. So this user-friendliness means friendliness for both the contracting authority and the contractor. And this job, and so for the purposes of this, we've developed 3 programs regarding procurement and their regulation, and its regulation, how to have e-procurement. That would be a 3-in-1. That covers the entire process from planning to payment. The information in the deal would be available, open to anybody who's interested, in particular to watchdog organizations. And 3, how this InfoMarket helps the market develop new services. I'll be getting back to that, but this is the scope. This is where actually the value of Open Contracting Partnership Data Standard and the digitization combined with open data and making it easy to use procedures, making it easy for a business to do deals, and this is the greatest kind of benefit. The second is what the Batory Foundation is doing today, and thanks for allowing me to comment on that, is how to regulate in order to meet the goals or the goals. We know that there's no better monitor of what a contracting authority is doing than a contractor who wants to know why they were or weren't awarded a contract. So in Poland, the open bids, public procurement, the openness of public procurement data. And in Poland, Poland was unique in Europe in its time. I worked in Poland before and it was obvious that the bids were freely available and that the evaluation was available. But this is not the norm worldwide or Europe-wide. It became the norm in 2014 for all of Europe. So Poland has a lot of experience, has a wealth of experience, and knows how to go about it. And when these regulations were being drafted, machine legible, so Poland was the first in Europe when it came to publishing data in a machine-readable format. But this data is no longer available as of 2 years ago, and Poland does not publish this data. And 3, there's the access to the public procurement market, and this market access can be obtained in a number of ways. And Karolis and I believe that the quicker, the more electronic the procedure, the better it is for SMEs, and that should actually be enough. So I won't tell you what we do in detail, but the one thing we've seen, when it comes to creating a consistent regulation that involves regulation, digitization, open data, and public information, it's basically called open government, and I have no idea how to say that in Polish, but open government has 3 parts. So it's supposed to be transparent. The government is to be accountable for what it does, politically also, but also to its citizens, and the users, the stakeholders of every service, be it analog or digital, should have access to full comprehensive information about how that service works, and should have should be able to provide feedback to the government on the way this service operates. And what we've discovered working together in public procurement, or looking at public procurement in Ukraine, and later, and since then we've spread out to 20 countries, including Kazakhstan, for instance. We're trying to convince them and Belarus to provide access to their public procurement. Slovakia, Slovenia, Cyprus, and the Czech Republic. There we're working with governments that are revolutionizing their approach to procurement and open data. So if a government enacts legislation or regulations that supposed to increase transparency, using open data basically does the job. Settled. If we have a system that says everything that's out there is available because it's available online in real time, once a decision was made, then we have full transparency of the procurement process. And this, again, is my favorite slide. I'm glad Karolis also showed it, because this is actually the dream of anybody who analyzes public procurement. So it's wonderful to have full, rough, raw data, but it's even better if this raw data is comprehensive, arranged, available real time, and available to everyone in the same degree. What we're supporting governments, we're encouraging governments to create a single source at central government level that would be fully open, that would be available to government, business, and contracting authorities. Of course, you need e-procurement for that, and you also need to assume that the contents of e-procurement are open data.
The second thing that we believe is our learning is that system integration and interoperability are difficult things. Karolis showed you that, but let me just offer one word of comment. Whenever you work with vendors for public procurement systems, they can add things. For example, middleware. So you can generate for your client or for the government a complete set of data of things that go on in the system, and it can be replicable. Last but not least, integration. Open data helps with the IT systems integration, and it is working in countries that we are present from, and it goes from zero trust in government, Canada, to 100%. By the way, Canada has an open data policy, and it's a policy endorsed at the local government, provinces, and federal government, and it has been so for the past 25 years. So these people trust government contracts enormously. Why? Because they've gone for digitization, they've gone for open data, and they created a platform for users of public services to share and to exchange. This is it from me. I understand in the afternoon we're going to discuss what we can do with data. Last but not least, a little commercial. What we have been doing with the partnership is, first of all, policy. Change needs to be promoted, and digitization is a challenge. But secondly, we embraced the topic of data. What do you do with if your data is abundant, is huge, and it's big data? So we work with countries where there's zero information to move them up to a full, structured, and available information in a one-stop shop run by government. This is our dream. Well, but this dream has come true in 6 countries, and not necessarily in the sort of countries that we would believe are the most advanced. Ukraine was the first country to achieve that for a very simple reason. Now, the situation in the marketplace in government procurement was dramatic. Now, only the selected few could participate in public procurement until the revolution. The share of SMEs in public procurement stood at 8%. Today, after 4 years of the new systems, is 80%, and 75% of SMEs have actually won at least one government contract electronically. Quite an achievement, I should say. So we're replicating this to countries such as Kyrgyzstan, Armenia, Georgia, Tajikistan. In Europe, we're trying to build a coalition with the European Commission on how to use data and how to build tools, data analytics tools. And I'm showing you the slide, and you can go for this electronically and read at a greater detail. Now, this can be fun, and this can be exciting. As a lawyer, I've always thought it was a boring thing, but this can be exciting. Okay, thank you very much. Let me give the microphone back to Grzegorz Makowski. Now, before we go back to legislation, because we've heard this statement, people need to have a view of things, and people have to have access. Now, who are we talking about? Well, surely there are businesses. There are businesses that are vigilant, but about their own projects. But who else? NGOs. We have NGOs in Poland who are looking at this. So Grzegorz will present one way of looking at government contracting or public procurement, a certain perspective. But surely this is just an example. If data are to be open, you can have multiple ways to approach that. Ladies and gentlemen, because we are slightly behind schedule and we have creme de la creme in the form of the President, Mr. President here, and I would like to hear more about legislation. Let me therefore make my points very brief. I will not get into the detail of what we started with in this meeting, the Integrity Pact. There's a workshop after the short break about integrity, the Integrity Pact. What I am going to say is I'm going to give you perhaps more background to the Integrity Pact. It's a pilot. Let's be clear about it. Practically, it's a form of an agreement between the client contractor and a community observer, which is given access to the whole procurement process. From day one to project completion and commissioning. And the foundation is working with consultants and advisors, and we are the observers. It's a major railway project of 1.5 billion zlotys. I'm a sociologist. Our consultants are the true professionals in the area, and as you can imagine, observing such a project for an average person in the street is not an easy exercise, even for people like me who have focused on corruption issues for years. Now, I like this slide, and it's a great point of departure. We have some information, we have some data, and we can make sure that such data are publicly available, structured, put into blocks, but this doesn't guarantee that people will be looking at it, and people will be looking at it actively. Now, we want to have active involvement, active monitoring of people such as us, observers. After 3 years of being a monitor of this public procurement, I have learned a great deal. But if I were just to be recruited out from in the street to monitor a public procurement project, I would feel on a different planet. I can do it because the European Commission paid for this. I can do it because I can talk to professionals, lawyers and engineers, who can translate what I'm looking at into plain Polish. And only then can I actually make my own contribution. But I'm not awed by this procedure either, because if you allow a total layman into the process, you can see some eyes opening. Now, it has opened my eyes, and I've actually been fascinated by public procurement for the past 3 years. And actually, it all started with open data, because this pact idea and the fact that the foundation has become involved in this comes from a public procurement risk barometer, which is a tool that we believe it can be used to put data into building blocks. So we decided that once we are making our way towards the little blocks of data, we might just as well go for the pact and get involved. So it has opened my eyes. I'm not sure whether it has opened the eyes of our railway client or the contractors or our fantastic partners in the ministry who has decided to take part in the pilot. But when we come in, we ask questions that appear to be quite obvious, but we don't believe they are obvious. So this can help us achieve some progress. And let me give you two examples. When we observed the public procurement, the contracting phase, sorry, we saw a conflict of interest situation. Probably nobody cared and nobody looked at it. But we were naive enough to ask if there's a relationship between the client and the contractor. Is there anything potentially difficult? And maybe we should consider this at a greater detail, and maybe we want to make sure that this is never accused of. We didn't make a big thing out of it. It wasn't a big thing, but it has been received by the client. The client actually not only endorsed it, but actually thought that this is a problem that should be managed and must be managed. So if we are sort of moving in ruts, and in the ruts we don't see the definition of the conflict of interest, now you are thinking in a certain way, and we need to put ourselves out of the ruts for a while just to see more broadly. So this is one of the examples of how we have contributed using our own perhaps naive perception. Secondly, a more interactive access to information, basically ensuring that there's communication going on, and Mr. Haładyj mentioned that. And I like the fact that this new draft legislation makes sure that clients and contractors communicate better, because at the end of the day, when communication is good, the contractor will and the client will go back to the market with a view to future projects. And so I suppose today communication is very poor. Information is not available to those who are trying to get government contracts. And we have red flagged this, and we are hoping that this will be a little contribution not only to this project we have been monitoring, but perhaps more broadly. So let me put a stop here. I could give you more examples, but I'll be more than happy to hear Mr. President here and about the plans. Thank you, Grzegorz. We've known each other for quite some time, and we have had lots of discussions in the past. So let me openly talk about open contracting. Now, dear ladies and gentlemen, we have heard several interesting questions, and I have another question that I have inherited from Mr. Haładyj, so I'll deal with this. But let me go one by one. Grzegorz wants to hear from me whether this new draft legislation is in fact promoting transparency and competition. It has a mega impact on that. When it comes to openness, when it comes to transparency, when we have access, when it comes to access to contracts, we are certainly continuing on a good path. And let me just tie it into Karolis's chart. Karolis showed 5 steps of collecting data without putting too fine a detail on it. There's the planning step, and we are improving that, as the minister mentioned 2.5 years ago. An obligation was introduced to communicate procurement plans, and we're still improving on this. It is now published in the public procurement bulletin. It's a one-stop shop. You don't have to look it up in 3,500 individual contractors' sites. Secondly, I said we are improving this, we need to ensure it is updated quarterly, and this is great information. It's kind of being demonized by clients who are complaining that this will be additional burden, but this means this quarterly or this more frequent update does give contractors an opportunity to plan, anticipate. And operationally, it's easy because this information is to be found in a single source. Plus, the minister mentioned that we have ensured greater competition. Those of you who are working with EU funds and anything beyond 50,000 euros must be published. It will be published, and it's great news for competition, especially for small and medium-sized enterprises. Moving on, preparation. In this phase, we are supporting market consultations, initial market consultation. And this is actually happening today already. Now, we all know that contract prices are volatile. I can start a planning process for a contract, and a month from now or several months into the process, the prices are different. And what happens to clients in this situation? They call off the tender, and they are looking again at the paperwork. They're looking at it and their requirements, looking at performance bonds, and they are reconsidering golden door handles and things like that. So people are taking steps to make tenders realistic, and then prices are more realistic and more reasonable, and there are more contractors, more bidders who find such projects plausible and viable. And we have discussed it with my colleague here, with Eliza. Public purchasing or public procurement must be logical. It's about purchase logic. We need to exercise the same logic as we shop personally. When I'm ill, I don't go to the cheapest doctor around. I go to a good doctor, who I can trust. If we have building contractors in the middle of renovating our bathroom, and they are claiming more money because additional things have to be done, I'm not saying to my wife, well, let me terminate this contractor and let me take another one. And that means another month or two of our bathroom not being available. And we don't want that conversation. And our wives are, they want efficiency and they want results. So there are issues that have to be managed, and no procrastination is a reasonable thing to do, because trouble will only multiply. So back to the logic. We need to use purchasing logic and needs analysis, pre-contract market analysis. These are things that must be done. Needs analysis. People are saying, why do we have to do needs analysis? And people do that feasibility studies are exactly what I'm talking about. And the government agency that is in charge of motorways, the National Road Directorate, is also involved in such feasibility studies. They are looking into zoning, siting, and environmental parameters. When we travel across Poland, we see some building sites which have been abandoned, half-started. So we need to do this right at the preparation phase. The tender announcement and the tender process, this is more or less fine. We don't have to improve a lot. So there's an announcement, there's a pipeline of projects also notified, so that's good. Selection of the best available bid. I suppose that things are quite fine, and Eliza has presented that. But look at the fifth step. I find it of top importance. 2 years ago, when I joined the office, my dream was to see such a document. And that is a public procurement completion report. I don't care if the contract has been awarded. I know the amounts, the estimated amounts. I know the bids, and I may know that price X has been selected. I can manage that. But what I miss is an understanding whether the contract has been done at X, or X plus 2, or X minus 2. Has this project been completed on time, or has there been a delay? So how can I analyze public procurement information if I don't know that? And obviously, such information may not be too nice on occasion, because budgets may have been inflated and time may have been extended, but we need to have that information to manage things. Now, similar contracts may take 1.5 years, for example, and a client wants to have it done in 7 months, including winter. And we can see that this is wrong, and this is creating potential problems. And if the client is insistent, and if we know that the client has seen extension of the time and increase of the budget by 50%, that's a lesson learned, and this can be fed into more quality planning. So, Grzegorz, this is actually responding to the question whether there's value in the legislation. There is value in the legislation. And I thank you, I thank the Foundation for taking part in the hackathon. I'm talking about the event last Saturday about, this was about improving this legislative proposal. Now, it all sounds nice, and it's nicely worded, but there's a huge problem in all that. I suppose the draft will be fine-tuned, certain processes and procedures will be streamlined, and then in force there will be case law jurisprudence. But there's one problem. It's the people. It's us. Because now we struggle with the question how we can increase the number of bidders. But we lack human resources. If we don't have people to process that, we will not, as a potential contractor, file another offer beyond 1 or 2. I don't have a capacity. If I am able to sell 250 man-hours a month, I will not be able to sell 500 because of my capacities. Secondly, errors, mistakes. On the 11th of October, the digital processes were introduced, and it has become the common system, but people make errors. People miss certain things because they're not well informed. And thirdly, people are lazy. Certainly, it has strengths because we are more creative, and we come up with ideas that make things easier. But what I'm saying is that we said, as the government office, that price shouldn't be the only criterion, and we have introduced a catalogue of other parameters, and we have communicated that to the market. And I'm looking at statistics. People don't want to use that. They don't want to benchmark. We have announced a contest for non-price bid evaluation parameters. People are not involved. If I read people's post and furrow, we hear from people that this has to be changed, that has to be changed, but they are not coming forward with formal proposals. We are receptive, and we are certainly open to ideas. So we need to be open, and we need to be proactive. But hackathon, it's a positive sign. In my office, people thought that no one would actually come to the hackathon, but the attendance was strong, and ideas were exciting, and we are still considering using some of them for the draft legislation. I'm looking at Grzegorz trying to chase me for taking too long a time. Last but not least, Eliza said that lawyers' life is boring. I have 3 children. One of them is a 14-year-old daughter. Now I see that she doesn't have to be a doctor or a lawyer. Let her be a data analyst. This is good. I'm not sure about boys. It's another decade. But this is a future work for my daughter.
Okay, thank you very much. And now either a feasibility study or a selection of either the feasibility study or the selection of moderator was not done well enough, because I need to ask for 10 more minutes for questions, and then maybe we can cut the workshop a little short. We can eat into the workshop, or we can take our coffee into the workshop. So we have until 12:55, 5 minutes for questions, 5 minutes for answers. Is that okay with all of you? Just to make it transparent, right? Tomasz Witkosz, I'm an operator of infrastructure and environment. I have a question to the gentleman. I've submitted my remarks to the new bill. And I have, there's a slightly worrying provision, Article 661, which is a procedure below EU thresholds. It's a new simplified, or the basic rudimentary procedure. In Article 660, it says that transparent negotiation is possible, and contractors will be accorded equal treatment. Then, in Article 661, we read that negotiation will be confidential and not disclosed without the consent of the other party. So, cannot be disclosed without the consent of the other party, which leads to the risk, so there's the risk that transparency will be curtailed. And so my question is, public consultation, will that, so do you propose to change that, or do you have another remedy lined up, or is or am I exaggerating? Am I taking too bleak a view of the risk involved? My name's Zielinski. In my work, I write I'm in the IT business, and I write terms or specifications for tenders. There's one thing you failed to mention, I think. I've been listening attentively, but I see that there's a problem with contracting authorities. So any supervision, then the supplier. So lawyers from offices often tell me that as the author of the specs in the contract, I need to waive. So the contracting authority, who's a civil servant and doesn't understand the technology, they ask me to describe the good or service, and then they say you have to give up any right to oversight of the goods offered. Because I don't know if you've been following the market, but in the IT business, I think the irregularities are the most numerous. We have a new case from the Social Security Office, and then to follow that up, so you have in 2009, there were guidelines for tenders in this business, which nobody reads. Everybody ignores that. I agree. I'm very impressed by the way contractors fail to take that into account. So is there any idea, is there any concept for procurement for some provisions to be seen as illegal? For instance, doing away with oversight, or another, again, if the contracting authority announces a tender and saying that they want the vendor of software to define the specs, then actually it's like me going to a carpenter and saying, tell me what to buy, and I won't ask any questions. So this is a topic that's been ignored for a long time, so I'd say it's even a taboo. Where the vendor, I think, drafts the specs. I'm a fan of this new public procurement law, but there's one thing I find I'm lacking here, namely, public procurement law, I think, would be better in terms of the specifications and consultation between the contracting authority and the contractor, namely answering the following questions. Could perhaps we restore the possibility of asking questions over a longer time period than provided for? And second, the Act perhaps could say that the contractor needs to provide substantive answers and not refer to some sort of document. The first question had to do with the basic or fundamental procedure. I don't want to jump the gun. There have been comments and remarks filed, and after the hackathon I also didn't comment myself. I'm looking at a number of very good ideas that came up in the hackathon. I'm very satisfied, I'm very happy. So I'm just trying to put it all together, so it would be irresponsible if I anticipated that if I answered prematurely. We're getting a lot of comments, a lot of them are interesting. Actually 30% of them could be put verbatim into the Act, because so the matter that your organization, it's a matter that your organization pointed out as well, and so we need to take that. And a lot of contractors didn't want to negotiate. They don't want to show their methodology, disclose that, because it's their proprietary know-how. So it's a question of finding a balance. Second question regarding IT and intellectual property. Or there have been comments made to the effect that the Act should address these, but these legal provisions, because it does overlap, it has been said that the president of the should be able to define abusive clauses, namely ones which should be banned in public procurement based on the case law of the Court of Appeals, of the Chamber of Appeals. So, and you can appeal against that. So if a provision or a clause is somehow inadmissible in terms of risk or whatever, the chairman of the Public Procurement Office will look into that, and these clauses will be introduced. Of course, it remains to be seen whether this will be sector-specific or more general, broken down by sector. And again, this relates to the social oversight that all of us, not just Grzegorz, care about. So Grzegorz kind of gave a face to it. And one thing we lose sight of, these are minor details. So you can appeal against every action or omission, whether it's above or below the line, below the threshold. If it's above the line, you need to have a 3-member panel. If it's below the line, then there's one person is sufficient to rule on that. So often we lacked oversight in the time, so now it's 14 days to appeal instead of 7. So we doubled the time where you can appeal, and if someone feels wronged, and there will be one court in Warsaw, and that means that the case law of the Chamber of Appeal will become uniform in a way. So if they rule and then it's overturned by in a higher instance, then so it'll be more uniform. And if there's something that's contrary, up until now we didn't have extraordinary appeal or so-called cassation. This cassation was only the prerogative of the president of the Public Procurement Office. Now parties will have the right to apply or move for cassation or extraordinary appeal. And the last question has to do with answering questions or providing more time for replies, or to force the contracting authority to provide substantive answers. This is a huge problem. Let's face it, in many specs, the question can be half a page long, and the answer is I confirm the wording, or I confirm what's in the document. Full stop. So we've had a lot of remarks, we've had a lot of objections here, and this is something we have to look into because we're aware of the issue. We need to look into, because there's also a second stakeholder, the contracting authority, who has their own perspective, and that perspective has its pros and cons. Again, it's complex, and it's something that we really need to address and work on. And let me just reply to the question that's been hanging in the air regarding catalogs. These catalogs have been, are out there, but there's very little interest in them, frankly, in e-catalogs. I don't know why. We've done publicity campaigns, we've promoted, we encouraged people to use them, these e-catalogs, but there's not a lot of interest. Maybe historically, I remember back in the day, this may have been due to IT problems or because the system would hang every now and then, but would crash, but there's not a lot of products and not a lot of vendors interested in supplying. So let me put it this way. And again, the question is, today, now that we have the procurement tools, do we really need this? In the platform that's been developed by the Ministry of Digitalization, there is a model e-catalog, so you have that option. But sometimes when I'm asked how to make procurement more efficient, people say that it can be done administratively. You can, I say that you can do it in 2 ways. You can say that we don't apply public procurement, so that's so we can use an opt-out, or you can have desuetude, to the effect that if you don't use that you don't apply public procurement law, then it will kind of fade away on its own. It will fall into desuetude. But again, these e-catalogs are simply not used. You can't force, you can't kind of make people use them. We've done, there was a huge promotion campaign, but frankly it didn't get us anywhere, and now we're out of options in terms of marketing. Thank you very much. Would the other panelists care to add something, or can I wrap it up?
Yeah, I definitely found this discussion more useful to me than me being useful to the discussion, getting about the details, about public procurement. But one thing that I think I contribute with is maybe just to push the logic a bit further, because what I'm hearing from many governments, including today, is that, do we have more transparency? And if we do, great. It probably means that we're fighting corruption. It probably means that, we can increase competition. But what we see happening and what we see the opportunity is that we can actually push this conversation forward with actually designing knowledge-based mechanisms. So let me give you an example. We spoke about technical specifications, right? The question is how, and we know who drafts technical specifications, businesses, right? Is it a problem? Maybe yes, maybe no. We don't know. But the least we can do with the current technologies to make sure that we have all the historic technical specifications in one database and use that as learning. There has been experimentation already where you have all technical specifications in one database and you have experts around. So it's great that UK are hiring, consultants and spending even more money on professionalizing the sector. That is fantastic. But the question, how can we use the data we already produce to learn ourselves and to improve our service? How about anti-monopoly agencies, competition agencies, anti-corruption agencies? How about increasing their capacity to do their job better with better information and data? That is the logic that I want to see manifesting itself in more countries, because this theory of change that will put out more data and automatically something will happen is poor. We can do so much more than that. And that's how we see the whole conversation go, and that's where we work together with DBRs, actually designing these mechanisms, speaking with people, breaking down the business process of institutions, understanding in which stages of business processes, which data is needed, and who should provide it and should use it to achieve what. It's about change of regulations, change of rules of work of officials within the agencies. It's not only about putting out data. And we are in the first stages of it, and we are experimenting in many countries, changing working policies and working behavior and environments of public institutions. It's the beginning. But in terms of the ambition, I would like Poland to have that ambition to push the whole system into something that you could call knowledge procurement, drawing analogy on knowledge economy, which is a very difficult thing to do. My grandma does not understand what I do. Knowledge, or you sell your knowledge? Well, what do you produce? I don't produce nothing. She's 97. Anyway, but this is something that I would like to see happening also in this region. It's about really knowledge-based procurement. That's where we should be moving. That's why I like your logic that when you speak about logic and applying that in procurement, but you cannot do that without good information and good data.
Okay, so we're back to system, but back to what we were missing in Poland.